Okay. Good evening and welcome to this public meeting of the Standing Committee on Social Development. My name is Jane Wayellen Armstrong and I am the MLA for Moonfie Cleacher Region and Chair of the Standing Committee on Social Development. I will now ask members in the room to introduce themselves for the record, starting to my left.
Left or right? Oh, sorry. Kieran Testart, I'm the member for Range Lake. Good evening.
Good evening, Danny McNeely, Sahtu Region.
Good evening, George Nirsu, MLA for the NZ Delta.
Good evening, I'm Shauna Morgan, a member for Yellowknife North.
Good evening, I'm Cheryl Yakalai, a member for the Decho.
Thank you, members. Committee has been tasked with conducting the first statutory review of the Mental Health Act since the Act came into force in 2018. It is our job to take a close look at the Mental Health Act and evaluate if it needs any changes or updates to best serve the people of the Northwest Territories. That is why we are joined here this evening by the Mental Health Act Review Board. Please note this meeting is being live streamed to the Assembly's social media channels. I would like to remind all members and witnesses to direct all questions and comments to myself as chair and to wait to be recognized before speaking to help us have a smooth meeting. I will now pass it over to our witnesses. Please introduce yourself and proceed with your remarks and presentation. Thank you.
Good evening, I'm Jeannie Marie Jewell. I'm from Fort Smith and I am a public member on the Mental Health Review Board. Thank you.
Good evening, Madam Chair. My name is Jacques Roberge. I'm a lawyer member of the board, and I am from Yellowknife.
Okay.
Good evening, Madam Chair. My name is Paul Falvo. I'm the chairperson of the Mental Health Act Review Board.
Okay, now proceed with the presentation.
Yes, thank you, Madam Chair. My colleagues have already introduced themselves, Mr. Roberge being a legal member and Ms. Jeannie Marie Jewell, one of our public members. All three of us have been members of the Mental Health Act Review Board since its inception in 2018. We are an administrative tribunal, as you know, and a check and balance that we have in our role is that in one sense, we are the property of the Minister of Health in the sense that the Minister of Health appoints us. We serve as members at the pleasure of the Minister. The Minister does the hiring and firing. And at the same time, we are mandated to serve at arm's length from the GNWT and to be independent in our decision making. At the cover page that you can see here is our logo, which is, of course, very different from the GNWT logo, and we did that on purpose. There's a practical reason for that, because for patients who appear before us who may be in a very vulnerable condition and may or may not be confident or have trust authorities, we wanted to show them that we were different, that we're independent, that we're not a unit of government, so to speak. And the logo also, it shows that we work at arm's length. It was designed in the North. I should say that Mr. Roberge and I have had some professional disagreement over the interpretation of the logo. I would say there's Aurora there, and there's a river, perhaps the Decho. And then underneath that, it's designed to look like the ears of a sled dog to symbolize that we work hard and we're listening. I will turn the presentation over to my colleagues. Jeannie Marie Jewell is going to tell you recommendations for improvement in the legislation in our view. And before that, Mr. Jacques Roberge is going to brief you on what we do. Thank you.
Thank you, Madam Chair. Thank you for your welcome, and it's a privilege to be here and to speak to this very important topic. And before I start, I'll just ask a question. Who here hasn't heard, seen, or known of a family member, a friend, a constituent, an acquaintance who has for a time or at some time been placed in front of a mental health issue and has been vulnerable? So this speaks to helping and providing the assistance to and protecting the rights of vulnerable people. So our presentation will have two parts. The first, as announced, will be done by myself to speak to who we are and what we do. And the second part will be by Madam Jeannie Marie Jewell for the opportunities for future developments. So moving right on, we are created under the Mental Health Act as MHARB, Mental Health Act Review Board, under Section 60. And as I announced, we help protect the rights of people who are in a situation of vulnerability, and a patient or someone on their behalf can apply to the board, to MHARB, to have a certificate reviewed or challenge a decision by a medical practitioner. There are 12 members of our board between three categories: legal member and lay member or member from the public, and medical members. Moving to the next slide here, essentially the Mental Health Act does three things. First, it's a component of a system of acts and regulations that create a medical health care system, fund it, create hospitals, healthcare facilities. And so the Mental Health Act is one piece of a system. Second, it, as I have already introduced, it is designed to provide help and assistance and care and treatment to people at a time of vulnerability or in a time of need. Third, it provides guidance to the medical practitioners and to board members and other stakeholders or people who intervene in regard to patients. This leads us to the guidance criteria on the next slide, which there are 6. First of all, this is from Section 2 of the Act, and essentially we have to avoid unreasonable delay. We have to respect the local people's culture and language. We have to promote the least intrusive methods on people's freedoms and liberties. We must value communities, families, and respect the entitlement to make one's own decisions, medical treatment decisions, to the extent of one's capacity at the time that they're in the system. And ultimately, privacy is paramount because this is a very sensitive topic. At the core of the Act is the concept of medical disorder. So it's defined as a substantial disorder of thought, mood, perception, orientation, or memory that grossly affects or impairs the judgment, behavior, or capacity to seize or realize reality and the ability to meet the ordinary demands of life. And that guides the doctors in many legal tests throughout the Act and the board through assessing various decisions. The Act has a number of components. We'll speak briefly to the entry points, how people enter care or mental health or the custody of the Mental Health Care Act. Involuntary assessments, involuntary admissions, The Act designates facilities through its regulations. We'll speak to patient rights. It creates the board, as I mentioned already, and a number of decision makers. We can name or add decision makers when the patient loses their capacity to make their own decisions. Patient rights is at the core of this act and guides the everyday work of the board. When somebody is held under the act, it is detention. Freedom is the rule, detention is always the exception. So patients need to know why they are held. To the extent of their capacity, they should make decisions for their own future, their own care. They may apply to the board at any time, and we can speak to the process for that. We will address that. Consult with the legal counsel and receive ongoing assessment, because the moment someone resolves or the mental disorder resolves, there's no reason to detain. The person should be immediately released, and that is done in part through ongoing assessment under Section 20. I've already mentioned privacy. There are 3 entry points. One is the dominant. Number 1 is the RCMP peace officer. Most of the cases we see, there's a precipitating event that triggers the intervention of the RCMP, and the RCMP apprehend the person and they're brought to emergency, and then there's a process that starts. The court can order in 5 years. I have never seen a court order, but it is provided for in the Act. And health professionals, at some point, a health professional, when examining a patient or caring for a patient, if they find that there is an issue, a mental health issue, they can temporarily detain for examination, and that happens from time to time, but definitely number 1 as entry point is the dominant one. I spoke to voluntary admission and I will compare it to involuntary. Involuntary, it's about the benefits. It's a medical assessment by the doctor. It's a patient-doctor relationship. When we get to involuntary, it's a legal test, essentially, combined with a medical assessment. That must happen in a given time during the involuntary assessment. They have 24 hours. And then there's a second assessment by a second independent doctor. So involuntary admission, there's a lot of, I would say, gatekeeping. You don't enter involuntary admission by accident. The detailed test for assessment is there has to be an imminent risk for the patient or the person to cause serious harm to themselves or another person, or a deterioration, serious substantial deterioration if there's no form of intervention, and the person has recently shown or manifested a threatening behavior that is usually the trigger that brings the RCMP in the equation and that triggers the process. This lasts 24 hours, during which we now move to the involuntary admission. So this is also a 3-part test. The doctor will have 24 hours to diagnose or pose a preliminary diagnosis, an admitting diagnosis for the health disorder. And the test is, again, the risk of harm, serious risk of harm to self or serious deterioration or impairment. And the patient or person is not able to or suitable for voluntary admission. Again, I emphasize, different purpose than the assessment, the involuntary assessment, and mostly by a different doctor, and it has to happen in the first 24 hours. Here I will go quickly. Treatment certificates are exceptional, but they are there when the person loses capacity. The doctor can either find a substitute decision maker or apply to the board for a treatment decision to allow the doctor, if they can't find a decision maker, to administer treatment. So this is an application we hear from time to time. When somebody is detained, there's additional rights that we have to watch for, and we do survey in the medical charts that the person has been notified of their rights to contact counsel, legal counsel, instruct counsel, make calls, have contact with the outside, have the same privileges as other patients, and have access if there is a substitute decision maker, legal guardian, or other person that is significant and of help. And again, I'll emphasize ongoing assessment and the privilege to speak out and seek out and communicate with the outside. Care providers, health professionals have corresponding obligations, which is to communicate in a language that patients can understand, in simple language. Also, to reach out to the family to provide assistance if there is the need for the family to help provide care. They also have that obligation. And to identify people that are significant and that can help the patient, and examine, this is ongoing examination, to ensure that the legal tests continue to be met, and this is something we look for in the charts. And provide patients with second opinions as required or on the patient's requirement. We are now at the step where I will speak to what we do. So we don't issue certificates. The doctor issues the involuntary assessments and the involuntary admissions. What we do is we review where the checks and balance. We are the place where they can apply to have a substitute decision maker named, or remove limits, or remove or cancel a certificate. Mostly it's the patients that apply, but people who have a relation to the patient, either through as a legal guardian or substitute decision maker or family, can also seize the board of an application within certain limits as provided by the Act. I will now conclude my first part with just a little bit of a flow chart here. So the way to start an application is by filling out a form. It is received by the board MHARB staff. The chairperson will evaluate or assess the application and make a decision whether they will hold a review panel hearing or whether they dismiss the application. And this will happen within 24 to 48 hours, and the 72 hours is that the applicant has to be notified within that time. The next slide, and that will be the last one of my part, will be to speak to another step. So once the decision has been decided, once the chair has decided to send the matter to a hearing, we must wait 7 days. We must provide 7 days notice to all the parties. And that's a topic that Madam Jeannie Marie Jewell will speak to in her part. There's an issue that we want to address. And then it goes to the last step is the hearing day. We will hold a hearing most of the time. And if the patient needs an adjournment or there's a technical issue, we can adjust the schedule and hear it a little bit later that day or the next day. So we're flexible with a patient-centered approach and in respect of the needs of all the parties. So that concludes the part I had to present. So we're now at part 2 of the presentation, which is opportunities for future developments. So Madam Chair, I would now yield to Madam Jeannie Marie Jewell. Thank you.
Thank you, Madam Chair. Thank you, Mr. Auberge. I have been on the board since it began and have noticed that the intention of the act is great to help people with mental disabilities or addressing mental issues. However, there is a problem that I have observed as a member, and many of the members also agree, is that, you know, the chairman has a couple of days to look at the application from the patient once they're assessed. If the patient wants to get their certificate reviewed by the board. But also there is a 7-day waiting period for everyone collectively to agree to a time frame. And you're looking at probably up to 10 days before you're answering a patient, which is a long time for them being held. And this is where my concern is, right in the act. I think if the 7 days and under section 70, 1B, I believe it is, of the act, it states that in 7 days, I think if we can seriously consider clarity, or not so much clarity, but to give more flexibility to the board to hold a panel hearing and to possibly look at on consenting within the parties to hold a hearing. And so if the parties can consent to hear an application within anywhere from a couple of days to within, you know, to even 5 days or 2 days, then at least the process is proceeding at a quicker pace. And then we're really making every effort to address the needs of the patients. And this is where I think that the committee members can have the say in the process to make changes for the betterment of the patients. That is one particular area. I think we have basically 3 areas for the committee to consider. The second area is, you know, like I have stated, that a lot of the applications and certificates at the last minute get canceled, and probably because of the patient not wanting to wait for the time frame to evolve. So out of 70 applications, and approximately 70 applications that we have received since I've been on the board in the past 5.5 years, it's safe to say that we've only heard about 15, and the rest have been canceled. And we don't know why they're being canceled. We can't follow up in respect to our annual reporting, any statistical reporting, why they're being canceled. And we feel that if there can be some amendment in respect to creating authority for our board to review the file and to determine the purpose of the cancellation. There are still many things that are kept extremely confidential. We recognize that. But I think it would help the board in determining how can we avoid canceling hearings that the patients want, even though they've requested it. So we would like to have some authority to post-cancellation, have a post-cancellation file review is what they are looking for. And all of the data would be, certainly that the retrieve would be kept confidential. We've never released the patient's names. In fact, when the chairman receives a certificate and appoints a 3-person panel, which is a lawyer, a doctor, and a public person, if they appoint the public person, for example, that may be from Inuvik, I don't even know who the patient is. I have no idea. I just know that he's asked for members to sit on the panel. So we have kept a lot of the, we keep a lot of the information highly confidential. So if we can find a way to address that matter, that would be extremely helpful for the board. The other area that we find that we need clarity in is the Mental Health Act allows for the role of a cultural advisor and for an elder. And the patient, it's upon the request of the patient. The problem, I believe, is they only come in at the hearing. They don't come in right from the beginning of the process. And I think that makes it somewhat, at times, difficult. And the cultural advisor and the elder gives a lot of moral support to the patient while they're applying for their certificate to be reviewed. And we feel that if it is at all possible, the review board would like to see that the cultural advisor and the elder be involved right from the time the patient puts forth their request for their certificate to be reviewed and to be canceled, and not only come in at the end. I have, personally, I think I've sat on 2 hearings in the past, since I've been on the board. And one hearing I recall a elder being involved, which really helped, you know, because you have a patient that is having mental problems and they're coming in front of a doctor, 2 doctors, one doctor from the review panel, their doctor, and they're also coming in front of a public person and in front of a lawyer. So, you know, it certainly helps them because the whole process, as much as we don't want it to be, it could be intimidating for them. So those are the 3 areas that we would really like addressed to allow us to help the patients when they want help. And it would allow for the flow of addressing them and getting them the help they need at a quicker pace. So with that, I thank you, and I'm open to questions or any further comments or discussions. Thank you.
Thank you for the presentation. I will now ask members if they have any questions. Mr. McNeely?
Thank you, Madam Chair, and thanks for the presentation. And it seems to me that for myself, I haven't heard of this board until now, so I'm kind of convinced, and I had one question answered, is how active is this board? How many cases have you seen? You said you processed 70 applications over the last 5 years, so it's functioning and producing its duties. And now you're experiencing some weaknesses and pointing out these 3 concerns, which to me seems valid. And I guess my one question is, how many other groups does the tribunal or this organization make awareness presentations to show the existence of this organization or this board?
Ms. Jones or?
I'll skip for that one.
Madam Chair, in terms of the numbers,
Okay.
what I can say is that
Can you just hold, please? Okay, yes, you can proceed now. Mr.
Thank you.
Vogel?
Thank you, Madam Chair. Two parts to that question, Madam Chair. So the first part on the numbers, our reporting year is the GNWT fiscal year. Over the past 4 reporting years, 3 of those years, we have averaged 16 to 17 applications, of which over 75% were canceled, sometimes just days before the hearing. Then in one of those 4 years, which was 2021 to 22, there were 4 applications and only 1 went to a hearing. So in one sense, we're like the fire department because we're sitting around and then we scramble when something comes in. And then often when we get there, it turns out to be, I could say, equivalent to a false alarm, and that we don't have a hearing. So the numbers are, they're not staggeringly high numbers. However, it's very important to the people who are making the applications. And as for presentations to other groups, that was something we talked about at the inception when we were just starting off in 2018. We talked about whether we would go on the road, whether we would make presentations to the public, and it's something we haven't done. We've talked with healthcare professionals, but not to the general public, and it's something we'd certainly consider doing, because we want people to be aware of us, but at the same time, until somebody is in the situation of needing us, they may not be all that interested. But it's something that we'd like to consider doing if budget allows. Thank you.
MLA McNeely, do you have a follow-up?
Not at this point there, thank you.
Just to give some example, we have met with the, I believe it's the Office Experience, used to be the Aboriginal Advisory Group from the nurses that are collectively across the north. We have met with them. I do know in Fort Smith that I've spoke to the individual there regarding the Mental Health Act, and I recall there are notices in our health center of the Mental Health Act. And I believe that our advisory board created some of that information some time ago. I don't know exactly when, but I recall seeing it quite some time ago. But to state that we've made presentations to Dene Nation or to different groups, no, we haven't. Thank you for that.
Mr. McNeely?
Thank you, Madam Chair. My next question is, how are the patients made aware of their rights underneath the Act?
Ms. Jewell or Jacques? Okay.
I will. Thank you, Madam Chair. Thank you, MLA McNeil, for your question. It's a very important question. There's various ways to make the patients aware. There's the wards, at least the one in Yellowknife, has a psychiatric nurse and a liaison nurse. Some places call them pivot nurses that coordinate between the board and the patient. The board never speaks directly to a patient or the board staff. It's exceptional that we would speak directly. So there's the hospital staff, there's a person that when there's an admission in the ward, in the psychiatric ward, there's a form, there's a checklist. And that checklist is put on the medical chart, and that is one of the things, one of the documents we look for, and they check boxes to say access to lawyer offered, phone calls offered, forms provided, pamphlets or leaflets, information provided. So there's a a checklist. When it's not there, it's a question that the board, or the panel, I should say, will ask at the hearing. And we have delayed or stopped hearings when we found that from the patient or somebody else that they had not been fully provided full access to not only their rights, but also their information, like their medical charts. So it's not uncommon that we'll give an hour or two or whatever the patient needs to look at their information, and with the assistance of a patient care coordinator to explain or to flip through the pages of their charts or find things if they're looking for it. So that's a start. It's not perfect, but it's at least a start, and we do look for that when we examine the records. Thank you, Madam Chair.
Okay. MLA to start.
Thank you, Madam Chair. Thank you very much for the presentation. I was involved with passing the initial act, but I will confess I was involved with some of those discussions a long time ago, and it's good to see how it actually falls out. I have questions around each of the recommendations you've made. So starting with the first one, you just for clarification, waiving the waiting period is it with the consent of all parties? Like how would we ensure that it's not rushed if one party doesn't want it rushed? Like would you require unanimous consent of all parties, or would there be another mechanism? Thank you, Madam Chair.
Okay, Mr. Robert.
Thank you, Madam Chair. Thank you, MLA Testart, for the question. So I'm drawing a blank here on the question. So the consent, I'm sorry, I'll restate the question to ensure that I fully understand. So the consent for the notice would be of yes of all the parties. I think that is the question, but the process is not always successful. So the recommendation is we attempt to set on consent a shorter notice if the hospital is available, if all the parties are available in a shorter time. Everybody says yes. The patient wants to get out yesterday. They want their hearing yesterday. And the hospital is not in the business, to my knowledge, of keeping people over what is necessary. There's a lot of demand, so they also have an incentive. So if the parties agree, that's fine. We also have to plan, and it is in the recommendation, so it is in the recommendation on the slide that in the event there is no consent possible, and that will happen, that there be a minimum set, but it would be set in the regulations, and it could be shorter than 7 days. 7 days has proven long, and if I had to throw a number, 3-4 days, and putting it in the regulations would be better, because it's easier to adjust once it's in the regulation. If the minister has control over the regulation, there's still a transparent process for that to happen. But if it's in the regulation, it doesn't require an act change, and it may make it easier to adjust over time. So that's the fallback position. On consent, in my view, would work the majority of the time, and the set minimum notice would be rather the exception. That's what I predict, and that's what my experience indicates to me. So that would conclude my answer, and I hope I covered the whole question, because I had a little bit of a blank there. My apologies, and over back to you. Thank you, Madam Chair.
Follow-up?
Thank you, and thank you, Mr. Roberge. So would you like the entire, the 7-day period that's set out in statute, would you like that waiting period, or would you recommend that waiting period move to regulation completely? Or preserve it and then have an additional section of the act that would allow for faster hearings if there's other circumstances? I'm just wondering how you see this flowing in legislation. Should we just move it all to regulation, or should we preserve some areas in the act? Thank you.
Okay. Mr. Roberts, sorry.
It's Roberts. Thank you, Madam Chair. We're open to both. If I had to recommend one over the other, it would be to have the principle set out that reasonable, something like a flexible concept in the act to give the general direction, the general principle. So something like the panel will provide reasonable delay to the parties, and then there's a subsection right before that says that the hearing must happen as early as possible. So that already creates a sense of time, and this part on the notice would be a principle that we have to give reasonable notice for the hospital, the staff, the patient, all the stakeholders and parties to prepare, yes, but the actual number and the detail would be in the regulations. So what it does, it sets guidance in the act, but the details are mostly in the regulations. So to summarize, I'd put it mostly in the regulations. Thank you.
Ms.
No, I think to.
Okay.
Thank you, Madam Chair. I was just going to emphasize that, we all know how the acts are developed. It's always a shall. It's not a may, or, it doesn't give you that flexibility. And in the act, it does say, shall give 7 days written notice of the date and of the place and whatnot. So what we would like to see is some flexibility. And I suggested that, not to tell you how to do your work, but to take out the 7 days, it's an entirety, and to look at on consent of all parties, that they determine a date and a time and whatnot. And this would, if you're concerned about the time frame, then maybe that can be looked at in regulation where the minister has a flexibility. But right now, it's pretty rigid. Thank you.
Thank you. Okay. MLA McNeely?
Yeah, thank you, Madam Chair. I recognize and support the urgency of getting getting that 7-day process waived there. I've experienced with this job, as you well know, you receive a lot of small town, small community concerns. And I've received my fair share of concerns over the last 5 months. And it's very, I would say very concerning, as well as very ridiculous in some cases, particularly around some of the escorts that are needed. So I really hear you, and I really understand the urgency in waiving that 7-day period, and the choice of the words given by our legal opinion, which is free right now there. So I guess we can take that at heart and say, okay, we've got a legal opinion to change the act here and move it to the regs. Mussy.
So it was more of a comment? More. Okay. Okay. MLA Morgan?
Thank you, Madam Chair. Thank you for being here and coming all this way, Ms. Jewell, to be with us. Okay, one question I have, just to make sure that we fully understand your recommendation about the role of the cultural advisor, and your recommended changing of the wording. So you want to add the part during the hearing at the very end, would that make it more specific so that the cultural advisor would not be engaging at any other time except the hearing? Or is the idea to make it, to allow the cultural advisor to participate more freely or more of the time? I'm having trouble understanding the purpose of adding the phrase during the hearing at the end of that.
Ms. Jewell?
Just for clarity, this is basically what happens. Say if I'm a patient and I go in and I apply for cancellation of my certificate, and I recognize that I can have a cultural advisor with me. How the process is once the hearing starts, the cultural advisor can come in. But for what we'd like to see is the cultural advisor be familiar with the patient, and the patient is letting them know that, you know, we want the support. We want them to know this is how we do things. For example, I'll just take it as an example. Years ago, it was common for a household to have 10 people in a 2-bedroom house, and they lived together and they slept in one room. Well, a lot of people in the South don't understand that. And if the doctors are from Stanton, and the doctors that we have on our board are all from the South, they may not understand our culture. So this is where a cultural advisor is critical in the process to get them to understand. And this is why we're saying that throughout the hearing, it's important for the cultural advisor to be an active participant. Not just when it's time to say, okay, I'd like the culture advisor to come in and just tell you maybe how we live during the process, you know? So I think it's just critical that they be involved throughout. I hope I clarified it. Thank you.
Mr. Rowe?
Thank you, Madam Chair. I believe that the slide that we presented, the words during the hearing, based on the question and based on the answer, that should be expanded and perhaps opened up and to reflect some flexibility for the panel to have the authority to involve the cultural advisor at the time where the patient seeks, and usually we're seized of an application, it goes to hearing. So we have the power to order production of documents. So there is part of the, and I'll borrow the, instead of moving through the slides, the ability, that part of the recommendation is the power to disclose information as necessary, as deemed necessary by the panel. So it could be at the time and to the extent deemed necessary by the panel. And I would probably loosen up the wording during the hearing. It's perhaps at a time deemed or appropriate by the patient or according to patient needs, something like that. I don't want to get in too much detail, but we do appreciate the question, and that is relevant based on the answer to perhaps modify a bit what's on the slide to make the wording during the hearing more open so that the panel has more flexibility. So that would conclude our answer on this matter. Thank you. Oh.
MLA Morgan, do you have a follow-up?
Okay, and so what I'm hearing is that the board wants to ensure that there's flexibility throughout all stages of the process to engage the cultural advisor. And so the wording as it is, without any changes, and I do understand that you want to add a clause or provision about disclosing information to the cultural advisor so they can perform that role, so that would be an addition. But in terms of the wording for that part, I wondered about, instead of during the hearing, just saying throughout all stages of the process. But it sounds like you also want to add something about as deemed necessary by the board. I guess my question is, should it be up to the board to decide when the cultural advisor is needed or not needed, or should it be up to the patient to decide? Because then the wording should be more as deemed necessary or as requested by the patient.
Ms. Jewell?
Chair. Ms. Morgan, it's up to the patient. It's always up to the patient who they want in the process. But currently, the Act reads that on request by a patient, his or her substitute decision maker, the patient's attending medical practitioner, the review board shall engage an elder or other person as a cultural advisor to a review panel. So it doesn't specifically say to a review panel during the hearing, and that's where some concern is, that the clarity we need. And it's always up to the patient as to ask or to let us know what they want. Because we're there to help the patient. That's my viewpoint. Thank you.
Ms. MLA Akelai?
Thank you, Jeannie and Mr. How do you say it? Roberts, yeah, thank you for coming and thank you for your presentation. Like Danny, I too haven't heard of this until recently, and the Mental Health Act, because I'm new, since November I'm new, and but I agree that time is, especially if you're dealing with mental health situation, time is of essence. And so waiting a long time, like you said, the hospital is not in the business of housing people. So the 7 days, like, are the people going to be housed at the hospital for 7 days until the board decides to do this? So, and if people wait too long, that's what happens. People cancel out. So that's. I agree that it should be shorter. If the way the proposal is written, it looks good. Also, follow up. After this is all said and done, is the person followed up with? How and what does that look like? And just so you know, the person is the patient, I guess, is going to be okay. And the cultural advisor, coming from a small community perspective, and the story that Jeannie gave is like, I grew up in a one-bedroom house too, kind of, you could say that. What wasn't a house was a cabin. And we all stayed in one room. So that connectedness we had as a result of that, the family connection was it is so strong because of that. I'm very close with my siblings. But if we had grown up in a house where we were separated by walls, I don't know what that would be like today. So having that cultural advisor and from the beginning, I think would serve to help the patient. If they, like when, it would really help to serve. It would really serve to help the patient. That's my comments. Thank you.
It's more of a comment. Okay. I do have a question too myself. Okay. With the point of entry points, there's three. There's RCMP, peace officer, court order, and health professional examinations. And you outline, MD, psychiatrist, nurse practitioner, RN, psychologist. I just wanted to know why social workers or medical social workers are not part of this. With the point of entry, how come they are not identified to be one of the people to make the recommendation or to do an assessment as well?
That's a good question, and that's something that you can change. It's just according to the act that we're following, and that is why that is stated that. It's in the act that, it eliminates the the opportunity for social workers or for people that work with the community people at the community level. And the act is absent of those, identifying those individuals. And they basically, like Mr. Auberge said, is a lot of them are involved with the RCMP bringing to the hospital. And then they get admitted. But I do know that social workers can see a lot of times the problems starting to be created and whatnot. And it's something that maybe be suggested to the Minister for inclusion in the Act. But currently, it's because of it being absent in the Act that we don't allow it. Thank you.
Works.
Thank you, Madam Chair. Just to follow up on the answer provided by Mrs. Jeannie Marie Jewell, the definition of health professional is provided in the Act, and it lists a number of professions: medical practitioner, nurse practitioner, a person licensed under the Act to practice as psychologist. But at the end of the definition, it does speak to a prescribed person or classes of person. So that gives the opportunity, and I have not looked in the regulations, I haven't seen social worker, but the expression as prescribed indicates that the minister has the ability to set some classes and include classes such as social workers. So if it's not there, and I can't speak, I'd have to search the regulations, but if it's not there, the minister could have the ability to add it, and it's certainly something that I, as a panel member or board member, would welcome. It's just one more entry point, and it's maximizing the professions and the professionals that we have in the healthcare system. Thank you, Madam Chair.
Thank you. And I have another question too. So I just wanted to ask, so how does the board deal with privacy when it comes to medical assessment?
Maybe the chairperson can answer, because the chairperson is the one that initially looks at all the applications. And I'm sure if the chairperson received an application from Fort Smith, probably wouldn't look at considering me to be on the board, or we declare conflict anyways. When I had to, for example, if I looked at a sitting on the board and it was somebody from Fort Simpson, I would determine whether there's any conflict, whether I knew them or their family members or whatnot. But I only see the name if I'm selected for the panel. I don't see it otherwise. So maybe the chairperson, Madam Chair, can elaborate on your question.
Mr. Falvo?
Yes, thank you, Madam Chair. The way it works in practice is if somebody applies to the board, initially I see their name. The members of the board don't. I see their name, I read their application. And then if it's proceeding to a hearing, I'll canvass the members of the board to see who is available for specific dates. But that's all they know at that point. They're being asked, are you available the week of May 6th? Or are you available between May 6th and the 15th for a hearing? Might be the question. We're not told who it is. So then I look at who's available, who's physically available in those dates. And I do take into consideration demographics because we're supposed to reflect the diversity of the Northwest Territories, both in the composition of the board itself, which would be the minister side, but also the composition of the panels, which is on my side. So, for example, I try to have a panel that has gender diversity on it. I try not to have everybody the same or from one place. As for the communities, though, I could say it hasn't been a problem so far, because, as Ms. Jewell said, if you're a member of the board, if you're selected for a panel, after you're selected, then you're going to find out the name, and that gives you then the opportunity to check, and you can say, "Oh no, that's my cousin," or you can say, if you've never heard about that person, then there's no conflict. You move on, but each member, there's the expectation, they're explicitly asked if they have any conflict. So it's up to that person, because if you're sitting on a panel, it's like you're a judge. It's like being a judge in court or on an administrative tribunal. So you're not expected to have any knowledge of the person beyond what you hear in the hearing. And so we want to have people who come from communities and represent communities, community interests and values, but we want them to be looking at people openly without any prior knowledge or any conflict. Thank you.
Thank you. MLA, to start, do you have a second set of questions?
Yes, thank you, Madam Chair. So on your second recommendation around post-cancellation file review, what do you currently report in your annual reports when it comes to canceled file reviews? Thank you.
Ms. Jewell or Mr. Roberts?
Chair would suggest that this be directed to our chairperson. Thank you.
Mr. Falvo?
No, thank you, Madam Chair. Work's underway right now for preparation of our latest annual report. But to put it briefly, when a hearing is canceled, we simply state that fact in the annual report. So there's a table in the report which shows the number and type of applications, but then it'll simply have a line or two. It might say it went to hearing and a certificate was canceled. It went to hearing, a certificate was upheld, or it might say the application was withdrawn before hearing. And it's so brief in that because that's all we know. In some cases, we'll find out, we know that the patient withdrew the application. We might even have amplification on why from the patient. But typically, we don't find out. We just know that we'll find out that the patient was discharged. Patient's no longer in hospital, so its certificate was canceled, so it's no longer relevant. But we don't find out the why. We don't find out why they were put on a certificate in the first place. We don't find out what changed. Was it a shift change? Because many of the doctors are, I think all of them are locums. They're visiting from outside. The rotation changes before the hearing. So we don't know if it's a doctor of a different opinion. We don't know if it's the patient got better. And we're always concerned. We don't want the system to be misused. We don't want somebody to be held until a hearing is imminent just because they can. We want to be mindful that that's not happening. We want to make sure there's always grounds if the person's being held. And that's why we're concerned about the number of cancellations, because we don't know what's behind them. Thank you.
Mr. MLA Tessler, do you have a follow-up?
Thank you, Madam Chair. No, that is, sorry, I should look this way. that is what I was asking, because I wanted to know, like, usually the purpose of annual reports when you are creating new powers, especially powers that detain people's fundamental rights and freedoms, you want to make sure they're not being abused. So is that, just to put a finer point on that, is that the concern of the board at this point, is that you can't make that assessment in an annual report? Thank you, Madam Chair.
Mr. Falvo?
Madam Chair, yes, I would say we don't have the information and we can't put it in the report, and we are concerned. Because, for example, I talk to colleagues across Canada, and I'm aware of instances, not in the NWT, but in one of the provinces, where a doctor would put somebody on a certificate, the hearing date would approach, person would be released from the certificate, the hearing would get canceled, and then the doctor would turn around and recommit them. So effectively subverting the inquiry of the board. Now, we're not aware that that has ever happened here in the NWT, but we just want to be vigilant so that we could detect it if it did. I mean, we're here to be a check and balance. So it's not that we don't trust our healthcare professionals. On the contrary, we have confidence for the most part, but it's our job to be that check and balance to oversee and inquire. And to do that from the different perspectives, from medical, legal, and community perspective. Thank you.
MLA Testar.
Thank you, Madam Chair, and thank you for the answer, Mr. Falvo. What would you report then? Like, if you had access to this, to the authority to review canceled files, how would you report your findings in an annual report? I understand that it'll be de-identified, aggregated, so you can't link back to personal details, but yeah, what information, I guess, would you be seeking to provide in a report that could tell a reader there are no concerns around the abuse of these tools? Thank you.
Mr. Falvo.
Madam Chair, I would say if we identified a concern, if we thought that people weren't being treated fairly, that the act wasn't being applied correctly, then that's something we would note in the report. I don't know if my colleagues can embellish on that, but that's what I would say. If we detected a problem, a trend, or something that was adversely affecting the people we serve, then we'd want to report that.
Roberts.
Thank you, Madam Chair. So yes, it's difficult to guess about information we currently don't have, but certainly presenting a table and looking in the, especially with the recommendation of post-cancellation file review, we would mine that data to identify trends and perhaps within the authority provided under the Act, do recommendations or at least identify issues for the benefit of the legislator and the public. And so that's what could go in the report. But right now, as Mr. Falvo said, a lot of information is escaping us. So aside from giving you general categories or speaking to statistics, and statistics, the ones that that I believe would be helpful in a report would be, we've already spoken to the number of hearings, the cancellations, but also the types of applications, and it could go to the extent of the computing the average times between the application and the hearing being heard. So there's various indicators that we are open to be created as we develop more or access more information and refine the reports from year to year. So that would conclude my my response. Thank you, Madam Chair.
Ms. Drew?
The other concern that I have is that, you know the patient's in the hospital wanting a hearing, and then all of a sudden before the hearing it's canceled. So to me, I'm wondering, how come the patient got well so quick? That's my concern. And this is where I feel that they're falling through the cracks of our system. And if we could review it, that would be great. Thank you.
Thank you. Ms. MLA Yakalaya?
One question I have, you mentioned the chairperson mentioned that there's representation from the Northwest Territories. So of your 12 board members, are all of them representing the Northwest Territories, the regions, the Decho, Satu, South Slave, Tlinchon, Wichin? Are they all, there's members all representing the whole territory? Question I have. Thank you.
Mr. Falvo, you want to answer that?
Madam Chair, I would say that's an area we probably need to, we could improve on, because we have a member in Inuvik. We have 2 members in Fort Smith. We have, I'd say the majority in Yellowknife. We have members living outside the NWT, but members aren't assigned to a specific region per se. So it's not like we have a member for the Decho, a member for South Slave. They aren't assigned that way. Interestingly enough, we're now going through the process of public member renewal, in that new public members are due to be appointed this year. And so there's an opportunity there to have people reflecting different regions. But I guess the short answer is that it's not regional specified. Like, it isn't directed that we have to have a certain number from each region. It just, there's a blanket statement in the legislation that the board's composition is to reflect the diversity of the people of the NWT.
Okay, Ms. Jewell?
Madam Chair, I am aware that the board does have the doctors from out of the NWT, because I think to ensure that they're not connected with the doctors up north, to ensure that there's impartiality. So the doctors are from the NW, from the south. And the board is comprised of lawyers. I would say most lawyers are in Yellowknife anyways, but the public, I think most of us are from the different communities. There may be a public member from Yellowknife, but I can't remember right offhand.
Thank you. Emma, do you have a follow-up?
Yes, I guess for the purpose of an act that affects Northerners, it's always my preference to have Northern things happen. And a lot of the times we're dealing with small communities, people that live in the smaller communities, and there's mental health issues. I guess I could say majority of them would be Indigenous people. So if we had people representing, because of safety, privacy, and legal stuff, it makes me concerned. So I'm thinking about that. Whether a person's voluntary or involuntary, kind of say committing themselves. So I'm thinking about that and how to organize all of that. So that is that's something I'm thinking about, and regional representation is important. That's how I see it right now. Thank you.
So that was more of a comment. Okay. Thank you. Mr. MLA Nurse, do you have a question?
Just probably, thank you, Mr. Chair, Madam Chair. In terms of the community at large being concerned, and the families, the family of the person who may be having some mental health issues, and the family does not want to admit it, but the community has seen action that shows that this person is suffering. Can the members of the community go to the RCMP and intervene? And from there, can the RCMP just sort of do some points of that's a point of entry there? Can he start his investigation, or or contact the board saying that there is a concern from the general public for an individual, for his safety or safety of another person or the community? Thank you.
Mr. Roberts?
Madam Chair, thank you for the great question, MLA. The entry point we're discussing is way before where the board intervenes. So certainly the RCMP are the first point of contact that we see from the files. I'm not there to see it when it happens because, as I said, the panels intervene at a way later stage when the person's been brought to hospital, has went through the involuntary assessment and all that, and they're challenging the certificate they want to get out. So what we see in the files, in the medical files, is that more often than not, RCMP turn into social workers or turn into community care workers because there is no other door to go to, nor other people to go to, and they're the conduit to initiate. The public can contact the board for general information on our processes or how to apply that kind of thing, so we can give. But if there's a specific case where a person is undergoing a mental disorder, a mental health issue, they're immediately at risk, the entry point is the emergency medical system. So the 811, the 911, the RCMP, and often the community nurse will see things happening, will do a note, will notify. That's what we see in the reports in the medical charts. We'll notify the RCMP, and then there's a team effort, and then the person is brought to hospital, assessed, and then enters the system. So that's the best I can answer because we see it way after the problem starts, way after there's a risk of harm or deterioration, and there has to be some form of intervention. Sometimes it could be days or a week when it comes to us as a board. So that's why typically we wouldn't intervene at that point except for general information that the public can ask. And that would conclude my answer. Thank you, Madam Chair.
Okay, MLA Versu, follow-up?
Thank you, Madam Chair. So in this case, if the general public intervenes and gets the RCMP involved, and so that would be considered an involuntary admission of the individual? Thank you.
Mr. Roberts?
So it would start by what we call an apprehension. It's basically the person is physically brought to the health center or to hospital, and then they're seen by a doctor on an emergency basis. And according to the process is they first have to go through involuntary assessment. So when the RCMP takes a person, it's called temporary detention. It's detention for medical examination or apprehension to bring to a medical center. It's a form of detention. It's involuntary. It's not yet the involuntary admission. They have to be brought to the hospital. They have to be seen by a doctor, go through what we call involuntary assessment. That is also a form of detention. It's not voluntary. And then after the first 24 hours, then to your point, it becomes an admission, an involuntary admission if they meet the criteria under the Act. That would conclude my answer. Thank you, Madam Chair.
Thank you. Thank you, MLA Morgan.
Thank you, Madam Chair. So following up on MLA Testart's questions about annual reporting, does the board publish any statistics about overall trends of people who come, or I guess you'd only know about those that end up having hearings, but for example, like number of children that this involves, or genders, or regions, or just overall trends about what you're seeing, or the kinds of people that tend to come to the board for assistance? And I mean, regardless of whether you're publishing those stats, are you seeing trends like that, that it's, you know, mostly people coming from small communities or bigger communities, Indigenous, non-Indigenous, and like, are you allowed to comment on those kinds of trends?
Okay. Mr. Roberts?
Direct the question, Madam Chair, to Mr. Falvo as the chairperson of the board. And if he wants us to add, we can, but he should first start. Thank you.
Okay, Mr. Valvo?
Thank you, Madam Chair. I suppose the short answer is that we report what we're required to report under the Act. So there would be opportunity for the legislators to change that and to put in the Act what you want us to report. But we also, of course, can only report what we know. So what in the annual report is we report on where the applications came from by region. So if you were in Hay River and you ended up in Stanton Hospital, and we use the same regions that the Department of Health does. So I think it would be then South Slave. The report would say an applicant from the South Slave. And the age is there. I think it's age and gender and where the person, where the application came from. But it doesn't say, we don't report on the ethnicity of the person. So somebody in Hay River whose family had been there for a few thousand years, or somebody who just arrived last week, would be the same in the report. And it happens more often than we might think, because and we don't have statistics on this, but I was personally surprised by the number of people we have who are not normally resident in the NWT, who were applying, for example, transient people. And we have people who are, of course, are not Indigenous, but we don't have a breakdown of those statistics. And sometimes I think we don't know. For example, as chairperson, when I get an application, I see the person's name, but I don't know. I don't necessarily know their heritage. And the board members who serve on the panel may learn that in the course of the hearing if the person discloses that or chooses to make representations on that. But we don't necessarily know. And so it's not something that's reported. And in terms of other trends, I don't know that we statistically see enough cases to be able to make useful findings on any trends or information that would be useful. But I would invite my colleagues to jump in if I've overlooked something.
Okay. Mr. Roberts?
I would just say answer that demographics are of interest. They can have their value. And the reports, there's a statutory minimum, but nothing prevents us to expand, and I think it's something that we can look at depending on what data we have and the quality of the data. But it's as Mr. Falvo said, it can be limited, and on the forms, there's some of that demographic information we do not capture. Age we can, because we have the date of birth, the community of origin we have, but things, other traits, it's more limited in what we collect, and we also have to be mindful in the application form of collecting the minimum that we need to discharge our duty and not be overly demanding, especially considering that when people fill out those forms, they are under huge stress. Usually they're just being brought to a place they don't know. They've just been informed of their right to apply. They don't quite know. So we keep, the forms are kept fairly simple, but certainly we can mine some of the data in the medical files, and we could, it's something that's open that we could do if it's something that U.S. legislators see as necessary or helpful, that when we go through the medical files, we could perhaps gather some of that information while keeping to the limits and the restrictions and the mandate provided to us by the Act. So that would complete my answer. Thank you, Madam Chair.
MLA Morgan, do you have a follow-up?
Yeah, I just have one further question, and it's on a different topic, but do you ever get just general members of the public who attend the hearings? Like, I understand that you have to notify all the parties, but are hearings open to just anyone in the public who wants to attend out of interest or something, or is it just limited to the parties who are identified? I'm assuming there's something in the Act that identifies who's officially a party. And do you think part of the reason originally in the Act that there was this 7-day period was to somehow allow for this notice, like that, for sort of anyone to be able to attend this hearing? I'm trying to understand why they would require the 7 days in the first place.
Mr. Roberts?
Madam Chair. So first of all, the 7 days is to inform the parties, and it was decided to give time to the parties to prepare. So the idea of a notice is to give time to prepare. And we found through experience, it's quite a lot of time to prepare, and usually the applicant is ready when they fill out the form. If they could have their hearing then, they would. So that's for the 7 days. Now, no, to answer the question for access, the public does not have access to the hearings for the simple reason that privacy is paramount. We have to respect the privacy of the patient, and we know in our society, though we work hard to eliminate taboos and prejudice, mental health is still something that carries, it's still a sensitive subject, so all the more reason to keep privacy, and it's also in the legislation that the information has to be protected and it's confidential and private. Now, that doesn't mean someone who's not a party can't attend. So we do allow the patient to select a support person. That person is from the public, but we immediately hold them to confidentiality, and we make it clear as when the panel starts that all the people in the room, staff, doctors, including panel members, even a security guard if they happen to be in the room, they're all held to strict confidentiality, and it's usually it'll be decided or suggested by the patient who they want there, and the Act prescribes or establishes which are the parties that have to be there or that have the right to be there. So that's a little bit how it works. So no, the public will typically not, or will never have access unless invited as a support person by the patient. Thank you.
Okay. Ms. Jewell, do you have anything to add, or Mr. Falvo, to the questions?
No, I answered.
Okay, Mr. Falvo?
Madam Chair, yes, like as Mr. Robert said, the hearings are not open to the public, and even as chairperson, for example, I'm not allowed to attend a hearing unless I have permission. So I was able to once, because I had permission from the panel and from the parties, the panel after consulting with the parties. And so for training purposes, even for our own members, we can't attend. And for the 7-day notice, I would suspect, and maybe I should caution this by saying one thing I remember from law school is that we were taught never try to guess legislative intent. We're not supposed to guess what you're thinking when you make laws, but I would suspect that 7 days notice sounds very reasonable on paper because of course everybody needs time to get ready and everybody needs to be notified. So it makes sense on paper. It's just that what we're finding in practice is that the parties often don't need 7 days. The patient would like the hearing to happen sooner. If they're self-represented or if their lawyer is ready, we can be ready. So there's no need to wait. And those days may feel very long to somebody who is not able to go outside. Thank you.
Okay, thank you. Thank you for the presentation. Seeing no further questions from members, I would like to say thank you to the Mental Health Act Review Board for joining us this evening to give us valuable feedback on the Act. If there are any members of the public watching tonight who have feedback to share with committee on the Mental Health Act, please contact MLA on this committee or email committee@ntsassembly.ca. Thank you. Thank you. I would like to say thank you to Jeannie Marie and Mr. Falvo and Mr. Roberts for joining us.
Thank you very much for your time.